Hi, y'all. It's Chris, and I want to welcome you to Bama Law. I wanted to go over this real quick. This is my second take at it. Uh, the one big case that everything's going to rely on the birthright citizenship issue. I would do a case brief on it, and well, I'm gonna try to do it in less than 20 minutes. Um, this is the case that both sides are going to rely on because it really never settled the issue of it. It settled it as far as who can get citizenship. Okay. And I'm going to try not to get into the weeds. Like, I'm not even going to go into the fact that the 14th Amendment allows Congress to um, pass legislation to further enable that act. I'm not going to get into that. All right. Because they can do things like per whom they can prohibit or enable for citizenship, such as people that are born to a U.S. parent on a ship, born to a U.S. parent in another country, because people move. They have to move temporarily or whatever. Uh, those things I'm not going to get into. It's just strictly about people coming here, having a baby. Are they a citizen? Okay. Um, this is a case of U.S. v. I don't know if it's Wong Kim Ark, or I know in China the names flip flop around. So my aunt's Vietnamese, and I know hers did too. Like, I believe the name we call her, I think it's like her last name, a surname in Vietnam, but anyway, it doesn't matter. So it's either Wong Kim Ark or Ark Kim Wong. It's one of the two. It was decided or argued in March the 5th of 1897, decided March 28th, 1898. So it was a long time ago. This is really one of the only cases. This is the, I don't want to say penultimate, seminal case. I don't like the way this. Hang on, this audio. I don't like the way it sounds. I don't think it's sounding all that great. They killed the gain. That's a little better. Yeah, that's better. So this is a seminal case. Um, this is a seminal case that dealt with, really, for the most part, the issue at hand is whether or not a citizen or person is a citizen simply because of their birth. Okay. I'm not going to get into all the congressional acts that have been passed, even like the Chinese Exclusion Act, etc. Because if you go back and look, the end of the 14th Amendment, it says this, the act shall be, um, basically Congress shall be able to enforce it by appropriate legislation. And that allows them a large swath to enforce it. Now, does that mean they have the right under that to change it? You can't change an amendment, but you sure as hell can enforce it by doing different laws that enforce it. So, a lot of people would claim, well, we're enforcing it by saying, well, if you're born on a ship, we're going to let to an American parent, we're going to let you be a citizen. Okay, we weren't born in the U.S., but Congress has enabled it. So the same thing for foreign countries. So that's Congress's power. Okay, under the 14th Amendment. So I'm not going to get into all of it. We're just going to stick with Mr. Ark or Mr. Wong, either one. There are some other cases that have sort of dealt with tangentially this issue, but this is the only one that started and basically ended it. This is it. This is the one. Both sides will use it in reliance, because although it does use the principle of just solely, or right of the soil, and I think probably incorrectly, connects it to English common law. Um, it does not deal with the status of illegal aliens. And so while you can say that, well, the kid can be a citizen born if they're born here. What happens if their parents are not legally allowed to be here? Does it matter? The court never said either one. They just said, okay, well, yeah, his parents lived here. Um, that's it, and he was born, so therefore he's a citizen. So let's go through this real quick. I've done enough rambling on it. Let's get into the facts. So it took him about a year from start to finish to deal with the case, which is very quick in federal court. It's ridiculously quick, and I would imagine even back then it's quick. Um, it took like a year and a couple of weeks. So 54 weeks. It's pretty quick. Now, he started out, again, he came back and tried to get off a boat. He was going to visit his parents. I think he was about 17, 18 at the time. And he tried to disembark, and they said, the customs agent said, nope, you're staying on board. You're a Chinaman. Nope. And of course, he tried to tell him, hey, look, I've lived here my whole life. I'm just coming back from visiting my parents. They're in China. You know, I'm a citizen. Nope, no, you're not. So they basically imprisoned him on the ship. So this all started in federal district court through a writ of habeas corpus, which is the whole point of it, which is bring the body forth so that we can get to know whether or not he should be detained. I believe the district court ruled that he wasn't, and then it just kept going from there. So the Ninth Circuit, then, or the Ninth Circus, as lawyers call it, and then eventually the U.S. Supreme Court. All right, so the facts of the case. Mr. Ark was born in San Francisco, California, to Chinese parents who were subjects of the Emperor of China. That's how old this is. We're talking right after the Opium Wars. So this is old. This is not recent in any way. But the parents, had resided legally in the U.S. at the time of his birth. That's the part where Trump administration is going to lean on, or I would, because the court never resolved that issue. They do state it repeatedly that they were legally domiciled. So does that matter? The court never said. They just said it, and then they said, and as a result, he was born here, and the amendment says X, he's a citizen. That's going to be, I think, the biggest part of any case that goes forward is, what the hell does it mean? Does it matter? Well, obviously the Trump administration is going to say, well, yeah, it matters. Absolutely, it matters, because you have to reside legally in the U.S. and have allegiance to no other country but the United States to fully subject yourself to the laws and jurisdiction of the United States. That's going to be their argument. And the other side's going to say, well, no, you don't. Anybody can drop off here and have a baby, and they're automatically a citizen. Just soli. That's the doctrine. Right of the soil, which again is tied into common law. Mr. Wong, after traveling abroad to China, Wong was denied re-entry to the U.S. on the grounds he was not a citizen due to his descent. In light of restrictive immigration laws like the Chinese Exclusion Act, as I had said before, there was a lot of laws against the Chinese, a lot of restrictions, a lot. And probably the two most regulated groups of people would be them and the Native Americans. And Native Americans didn't even get citizenship, I believe, till 1923. So it's not that long ago, a little over 100 years. So the issue in the case is, does the 14th Amendment of the U.S. Constitution grant citizenship to individuals born in the United States regardless of nationality or status of their parents? All right, that's the first issue that you'll come to in the case. Anytime you're doing a legal paper, you use IRAC, issue, rule, analysis, conclusion. You find the issue. This is it. Next, we go to the rule. What is the rule? Yes, the Supreme Court ruled that Wong Kim Ark was a U.S. citizen under the 14th Amendment, which states all persons born or naturalized in the United States and subject to, this is going to be the key part, I think, in any litigation that goes on with the Trump administration. Well, the United States government. Let's go that far. It's the U.S. government. It might be the Trump administration. It's the U.S. government that's trying to impose this new definition of what a citizen is. It's what's going to happen so when you see it, it's going to say U.S. v. such and such, or such and such v. U.S. Subject to the jurisdiction thereof. That's a key statement. Are citizens of these United States. And then, of course, at the end of it, it talks about Congress has authority to enforce the article by appropriate legislation. Doesn't say what. It just says they can. All right, so the reasoning or the analysis in the court opinion is the court interpreted the phrase subject to the jurisdiction thereof to mean all individuals born in the U.S. except those not fully subject to U.S. law, such as foreign diplomats or enemy occupiers. That's bizarre. Okay. The court leaned on the common law principle of jus soli, right of the soil, affirming that birth within the U.S. confers citizenship. you could easily take that, I think, most likely, and say, well, wait a minute. Of course, it doesn't apply to them, diplomats and the soldiers of an enemy occupier. Of course, it doesn't. They don't have allegiance to the United States. They're not even ascending to jurisdiction. In fact, obviously, if you're here illegally as a soldier, I mean, you're an invader. You don't have anything. Diplomats are here merely as just an invitation. It can be revoked at any time. You have no right to be here, which goes into the same argument of, well, wait a minute. If they don't have a right, why the hell does an illegal alien have a right? And if they don't have a right if a diplomat can be revoked at any time they can be revoked. If they don't have a right for just solely for their children, why in the hell should an illegal immigrant? What difference there's no difference between the two. They're still human beings in the United States. And it goes to the issue of do they assent to the jurisdiction thereof? Who do they have allegiance to? That's a big deal. And I think it may be what pivots the issue on it in the end. In the ruling, let's see, we've talked about that in the ruling. The reasoning is that the court interpreted the phrase subject to the jurisdiction thereof. Here we go. So this is going to be this is the wording right here. Subject to the jurisdiction thereof to mean all individuals born in the U.S. except those not fully subject to U.S. laws, such as children of foreign diplomats or enemy occupiers. The court leaned on the common law principle of jus soli, affirming that birth within the U.S. confers citizenship. Again, why are you excluding one but not all? That makes no sense. How can you say, okay, well, a diplomat doesn't have that protection, or their kid can be a citizen, or an enemy occupier, but an illegal alien can? How does their kid automatically? It's inapplicable. It's indefensible to have one singled out and say, oh, well, as long as they're not a diplomat, they're okay. Because Congress has said diplomats and enemy occupiers, they can't have citizenship. What's the difference? They're both here, non-citizens. They both have a kid. There's no difference. So why can't we let diplomats have children? Well, because Congress said so. Well, if that's the case, all we got to do is have a Congress pass a law. That's where the president, I think, is going to run into an issue is, can he do what he did by executive order? I'm not sure. Can Congress? I think possibly. I think it's a good argument, and I think the court needs to make a decision in the end as to what the hell did this court leave out, whether or not these people who resided here legally, could their child get citizenship because of that when he was born here? The issue is going to be, if they're illegal, if that's the case and they were here legally, does that change it? Does that legal status of his parents somehow change whether or not he can get citizenship? I think because of this being the issue, it's opined in the case, but it's not the issue. It's almost as if they took it as a matter of fact that, oh, of course, the children of legal residents can be given citizenship. No one asked the question, well, okay, what about an illegal alien? I don't think, and I know I'm going to show a quote, if I can find it here, from one of the 14th Amendment authors, or the push for the amendment, as to what he thought about this in a minute. Okay, so the ruling was yes. The Supreme Court ruled that he was a citizen. I covered that. Reasoning. The court, and here's the phrase, and that's going to be, I think, key. As the court interpreted the phrase subject to the jurisdiction thereof to mean all individuals born in the U.S. except those, as I've said, diplomats and occupiers. The Supreme Court's decision in U.S. v. Kim Ark, or Wong Ark, established a critical precedent affirming the constitutional principle of jus soli, granting citizenship to nearly all individuals born in the U.S., regardless of their parents' nationality or immigration status. That's the problem. That's what we're trying to fix, not the fact that he's trying to say, well, no kid born here, unless an American citizen or to an American citizen, can be a citizen. Every country has that rule. Almost, I don't know of any other country that doesn't. I think the argument's going to be you can't come here illegally and be expecting the U.S. government to recognize the child of an illegal alien to be a citizen because you're not submitting to our jurisdiction. You're clearly not. You're breaking it. You're here illegally. It granted citizenship to nearly all individuals, regardless of their immigrant status. This ruling solidified the 14th Amendment's expansive interpretation, ensuring that birthright citizenship serves as a foundational element of American identity and inclusion. However, the decision also invites continued legal and political debate over the modern implications of the principle, particularly in the context of unauthorized immigration and evolving national policies. Now, the argument is going to be, everyone has made for 100 years the argument in favor of birthright citizenship. It's been done. That's what's going to be done in court the next few months. It's already been done on a district level with an injunction. That just holds everything. He could still go ahead and tell them to shove it and do it anyway. It's not like, what are they going to do? Stop him? I mean, I don't know. They couldn't stop President Jackson after they said, no, the Bank of America, no, Bank of America can go on. Oh, no, it's fine. Of course, he had his famous quote then, well, Mr. Chief Justice, you have your ruling, now enforce it. What are they going to do? Nothing. Ain't nothing you're going to do to the U.S. president. Nothing. Not unless someone goes against him and goes and somehow arrests him. Good luck getting past Secret Service. It's not going to happen. So I thought what I would do, I tend to favor the argument that the administration is putting forth, that I don't think it applies to illegal aliens. I just don't. That's an absurd thing. No country on the globe allows that. You can't. It'll just water down everything else that we have. Our right to vote, everything gets watered down. You can totally change a populace. And as people are trying to do now by importation of people, human smuggling, in order to just change the electorate, to get their vote, to have their boot stomp on the neck of their opponent. Hey, look, you bring in 10 million illegals. We'll just say 5 million have kids. That's, if you get them somehow a voting right, you've got 10 million plus another at least 10. That's 20 million people. You'll never lose an election. Never. It's never going to happen. You will always win. That's wrong. They should not be able to just walk across the border and be conferred a right that other people had to fight for. I have a dear friend of mine who's like a brother to me. Came from Russia. He had to come the right way. And he was running from communism. He had 3 strikes against him, in fact, and his parents. They weren't communists, very bad, or socialist. They were Jews, not good. Let's see, not communist, not Jews. I forgot the other one. Anyway, they had strikes against them. It wasn't just that they were they didn't like their country, or they had ideological differences. No, they were hated. They would have been thrown in jail before they followed the Soviet Union. So you're not a communist, and you're a Jew. It's bad, and so they got out. They came to the United States. I can't imagine what they went through. I've talked to him many times about it, but it pisses him off so bad when he sees people come here, get all the benefits of being a citizen, and they've never had to do anything but cross the border. Nothing. They don't do anything. They cross the border, poof. That's it. Kid's a citizen. It's not fair. It's not fair to those who come through the front door. That's just my opinion. You can, leave a comment. Please let me know. If you disagree, that's fine. Just keep it civil. Just let me know why you disagree. That's fine. If you want to quote a case, put it down and I'll take a look at it. That's fine. But that's just my opinion. So I wrote a little bit of a counter argument now that we know the actual law there. I think the major case that they're going to be looking at, and I think it's going to turn mostly on whether or not a person is a legal citizen or a legal resident, or legally domiciled, which to be domiciled, you got to have lawful status in the United States, which, yeah, hey, look, if you get somebody who has a green card or a legal resident, they may not be, they're obviously not a U.S. citizen. I don't care. They're from Great Britain. They have a child. I have no problem because they're staying for whatever reason. They're staying an extended period in the United States. They're here legally. We shouldn't expect people that do that. Obviously, if they become citizen, then it doesn't matter. But we should not expect people that, such as lawful residents, to come here and go, okay, well, yeah, if you have a kid, yeah, don't expect it to be anything good. You know, you're just going to have to go back to your country with them because they're not going to get citizenship status. That's fine. Congress can do that. They can make that law. I think that's fair. You know, they've come through the front door. They have done everything except take the oath. That's the last thing they have to do is take the oath. They've done everything else right. It's not fair to them. Every person that you allow to come in the back door and drop a baby off, okay, you're taking away from those that came through the front. It's wrong because it's a hell of a process. It is a long process. Just getting your visa can be a long process, not to mention your residency. Holy crap. Even from England, this isn't easy to get, and people just don't realize it. I don't even know if they care. They usually have a political end game. This isn't about politics. It's about fairness, fundamental fairness. Is it fair to do it to one group at the expense of another? I don't think so. So I've wrote up a little bit of a counter argument in favor of limiting birthright citizenship. All right. So the intent of the 14th Amendment, what was its original intent? The amendment was primarily designed to guarantee citizenship to formerly enslaved individuals and their descendants because they were all viewed as just chattel, not as a citizen or a person, chattel. Okay. 13th Amendment's passed, no longer slavery. But a lot of states are saying, well, they're not citizens either. That's a problem. We have an issue. You know, can't have them in government, can't have them participating in society if they're not a citizen. That is an issue. We don't want them getting deported, even back then, even though that did happen. Trust me. The country of Liberia and what is it? Is it Sierra Leone? Has Monrovia? There's a town called Monrovia. It's a shithole, but it was founded from President Monroe kicked out a bunch of slaves, and they went to Africa, and then in Liberia was also founded in the same way. So, you know, they didn't want to deport them. So they had to do something to give them citizenship. So they passed it. They couldn't do it with just congressional edict. That's not going to do it. The states had the authority to regulate that. So they passed an amendment. The states gave up that another right, which is always what happens. They gave it to the national government, and they said, okay, they're citizens. That was the whole point of it. It was, I don't think if you had told them in 50 years that there was going to be a case like this where they were going to give citizenship to someone born here from immigrant parents, that they were going to get citizenship just because they were in the country, I think they probably would have laughed at you and said, no, this only applies to former freed or the freed slaves, people formerly in involuntary servitude. They should have wrote it that way. But, people don't think about that stuff. There's things that we do every day where we don't think about the repercussions 20 years from now, especially not 50 years. So they took something that was probably just, hey, everybody knew this is why we're doing it. Let's just state it so no one can argue with it, and we'll give them a citizenship and they can be a citizen. They never dreamed to say this is only applicable to former slaves that have now been freed, because it was passed right after the war. This wasn't something done in the 1880s. We're talking 1868, very, very soon after the war. So there was a reason for it. It wasn't to give uh, to make people feel, warm and fuzzy because, oh, a poor immigrant came here and they had a baby, so now they can stay because they're a citizen. Their child's a citizen. They didn't care about that. They cared only about the formerly enslaved individuals. That's it. Former enslaved individuals and their descendants, not to establish universal birthright citizenship. The context in which it was enacted did not account for modern complexities of immigration or illegal entry. That wasn't an issue. You could come and go from Mexico into Texas. You go buy a gun at the Dollar General, not that Dollar General, the actual originals, your country store. And go back to Mexico and on horseback. That was common through that time, up until the late 1800s. It was a common occurrence, and even until 1916. That was the last incursion we had into Mexico, which was to blackjack Pershing, and he took a guy at the time I think was a major. You might know him better as George S. Patton Jr. He went with him. He was one of the. In fact, there's a little infamous story of him where he went off on a unsanctioned little recon. Ended up getting into a shootout with some Mexicans, killed them, tied them to the front of his truck, and brought them back to camp with the boys that he had with him, about 5 or 6 troops. And that was Patton's baptism in battle. And of course, he later became to be one of our greatest generals in the Second World War. Whether you like what his conduct or not, he was a genius tactically. But we Pancho Villa, he was killing Americans. He'd gone and made excursions into, I believe, Texas and New Mexico. I don't know about Arizona, but I know New Mexico, where he had killed Americans, just like the cartels are doing today. So we had an incursion into Mexico. They wouldn't do anything. We took care of it. We never caught him. The Mexicans ended up killing him. And then, of course, we had entry into the Great War, which killed it. Otherwise, we probably would have kept the Yucatan and other areas. It's a fact of history. I implore you to look it up. So the intent was primarily designed, again, to guarantee citizenship to formerly enslaved individuals, and their descendants, not immigrants. They were of illegal nature. The big question is going to be, and I don't know, I don't think it's going to get answered until the Supreme Court deals with it. It's just a fact. But the issue is going to be, what does subject to the jurisdiction thereof mean? What the hell does it mean? That's going to be the problem. What does that mean? Well, it can be interpreted narrowly to exclude children of illegal aliens, as such parents have not fully subjected. And this is an argument that was made at the time with some of the senators who debated the issue originally. And even the dissent on in the Supreme Court, they even brought this up, that, hey, this is kind of an issue. You've got this really wide description of what that means. When they used that subject to the jurisdiction thereof, they were using the common law principle of jus soli, which is huge and expansive, and nothing's tailored. There's no narrow tailoring of the concept. It's just large. And so the justices had a problem with it. Such as this phrase is interpreted narrowly to exclude children of illegal aliens. As such, parents have not fully subjected themselves to the U.S. To U.S. laws by entering or remaining in the country unlawfully. Clearly, they're not subjecting themselves to the U.S. law. They're here illegally. Period. They haven't even started their first day correctly. They're here in illegal manner. They're breaking the law. Illegal presence undermines the principles of voluntary allegiance required to invoke full jurisdiction. They do not have allegiance. They can't. They're here illegally. That was also brought up by one of the justices. I think it was one of them didn't take part, and it was 6-2. So of those two, this is kind of what they say in their dissent. Is like, look, man, this is way too expansive. You've got to assent to jurisdiction. You've got to say, okay, I acquiesce. Yes, I am under, for instance, even if you're under a subject under a king, if you come into that kingdom, you've got to acquiesce to the king to be a citizen. You had to do that. Otherwise, you had to leave. You had to take but, get up, and leave. There was no in between. All right. So encouragement of lawful immigration. Providing citizenship to children of illegal aliens creates a potential incentive for unauthorized entry, which is what they're doing. They're not stupid. Hell, I'd probably do it too if I was in their boat, but I'm not. I was blessed. Period. And I don't, make. There's no qualms about it. I'm blessed. I was born in the greatest country of the world. Sorry if you're not a part of it. It sucks. We have rights that none of y'all have. None of you, nor will you ever have. We have it, and we should cherish those rights, and hold fast to them and not want to give them up. Unfortunately, many people will give them up for safety, which is then you're neither safe nor free. But this allowing them to do this, this really impedes lawful immigration, because there's no reason to obey the law, which is what we're seeing when you have 5 or 10 million illegals come across the border. And they're not going to be able to deport them all. They're not even going to be able to find them. It'll take decades. It's just, this is a nightmare. But it was allowed because of one reason, which is politics, to get a vote dominance. Because then one side can tell the other side, go to hell, I've got you under my freaking boot, and I will crush your neck if I feel like it. There's no difference between it and what the Nazis did or the communists did. No difference. You will submit to our authority. That's the whole point of it. Restricting birthright citizenship would reinforce respect for U.S. immigration laws. Absolutely. Absolutely it would. There's a resource burdenship. Granting citizenship to children of illegal aliens places a significant strain on public resources such as healthcare, education, and social services. Excluding such individuals could alleviate these pressures and ensure resources are allocated to lawful residents and citizens. Absolutely, they should be. Why in the hell should we give it to an illegal? You have 50 free healthcare plans that you can give out. We'll just say that. All right, you got 50. Do you give it to 50 illegals, 35 illegals, and 15 legals? Or do you say 50 legal residents and citizens get to have these free policies? It's a bad example. I'm not arguing for socialistic healthcare. I'm just saying you have it. It's a resource. You have it. You need to allocate it. You could even use money. Just, hey, we're going to give free money away. Bad idea, but it's done every year around tax season. So do you give it to the illegal? Well, they're going to put it back into the economy. Okay, I don't care, because there has to be a reason. Look, there's a reason why it's a benefit to be a citizen. What the hell is the point if you're just going to give it away? So you're creating a problem with the immigration system in itself and a burden on our resources by allowing this. That's a problem. A modern comparison. Many developed nations, including most of Europe, do not follow the jus soli principle of citizenship and instead confer citizenship based on jus sanguinis, and sanguinate meaning to lose all your blood, right of blood. I don't know, I didn't say it right. I don't speak Latin. Not many people do. Or parental citizenship. The U.S. could modernize its approach by aligning with these international standards to address contemporary migration challenges. A lot of people are going to say, I don't want to be like the rest of the world. I don't either. I don't either. But I don't think that that's a bad decision. For once, it's probably the better decision of the two. You just can't. What they had in 1890s is nothing like we have today. You just didn't have it. You had immigration, yes, but you didn't have it on the scale we have now, especially illegal. They would have lost their mind if they had this like we do today. Because remember, they didn't have antibiotics. They had a lot of tuberculosis, a lot of bad diseases coming into the country through immigration, which was the number one way to get you declined. If they thought you had measles or mumps, rubella, German measles or whatever, you were gone. You were not coming in. You were held, and first ship out, you were gone. So they'd have shut the damn border down. They wouldn't have nobody in. They had known that, or if they had that same issue then as now, because they could not have processed the people quick enough. It would have been impossible. We allow it today for politics. We can totally take care of it. We could do, I don't know, probably process 500 to 1,000 a day if we really wanted to, if we put the money behind it. But at least we would know who they are, where they've come from. Are they healthy? Do they have a disease? We would know. We don't do that now. We just give them a rubber stamp and say, all right, go on about your way. We'll see you at your hearing. They never show up. It's a known scam. It's a scam. They are We are allowing them to scam us. That's what it's come down to. Regardless of whether or not they truly want to be here or not, for purposes of becoming a citizen or establishing a new life with a family permanently, and changing their allegiance, getting rid of their stupid Guatemalan flag or Mexican flag, whatever. They come here like the Italians did in the 19th century, 20th century. Yeah, you might have one flying or whatever, for, I don't know, some holiday or whatever. But when it came down to it, it was just an American. They only flew the American flag. I mean, many of them didn't even allow Italian spoken in their home because they wanted their kids to be an American. That's what we're faced with today. So I think, let me know if you disagree, but I think that's probably the best way is to do what other countries do. And even England's that way. You can't just drop a baby out of your womb when you're visiting. Look, here's the thing. If you can't do that now while you're on a visa, okay? You're on a visa for school or whatever, and you drop a baby out, it's not a citizen. It's not a citizen. Congress has said that. Okay, then why is it okay when they're illegally here? Because I don't think it was ever contemplated for that. I think the court never even, for one, the issue wasn't brought up. So the court doesn't like to get involved and start putting its feet into murky waters of issues that aren't raised before the court. Occasionally they will, like with Marbury v. Madison. The court kind of took it upon itself to do that, to get into using a case to get into principles of federalism and who's the most powerful branch of government. But this is a problem that we have to deal with today. And I think until we get it figured out, we have to treat people equally. So you either have to give citizenship to those who come here as diplomats, students, work visas, whatever, here for 4 years. They should be able to have a child have citizenship as easy as it is for an illegal. In fact, it's easier to come here illegally and have a kid, have them get citizenship than it is vice versa. But as of right now, you're not allowed to do it the other way. That's regulated. It's supposed to be. It's not, but it's supposed to be. It's on the book, or they're on the books. The only one that we haven't dealt with is illegal. We've covered resource burdenship, modern comparison, prevention of abuse, anchor babies. Huge problem. Critics argue that automatic citizenship creates an avenue for birth tourism, which happens every day. People come from China in groups, pregnant at their 9th month, when you're not supposed to travel anyway, so that their kid can come here, have a birth, given citizenship, go back to China, live, grow up, and then come here and live legally and go to school. That's what they're doing. They have literally tourist groups that do that, which is illegal. They're not supposed to get it, but they do because no one freaking cares to look into it and go, oh, well, wait a minute, weren't you here on a tourist visa at that time? Oh, well, you don't qualify. Again, why shouldn't they? Why shouldn't they qualify? If you're going to let illegals qualify, why shouldn't a tourist qualify? For God's sakes, at least they're legal. I think you run into some equal protection issues that, again, Do immigrants even get equal protection? That's a whole nother video. It's a whole nother one. Anyway, the birth tourism or strategic entry by non-citizens seeking to exploit the system. This is a real problem. Birth tourism is real. You can look it up anytime. In fact, I'm going to look it up. Let's look it up. Let's look it up. Hang on. U.S. birth tourism. Let's see. Yeah, here we go. Bing pulled it up. Let me hang on a second. Let me see if I can't share this real quick. All right, we got that. You're looking old there, Chris. Woo, yeah. Yeah, there we go. Let's see, did it come up? Yeah, it did. Birth tourism. Oh, shoot. No, that's not what I asked for either. Come on. All right. Birth tourism refers to expecting mothers traveling to the United States to obtain U.S. citizenship for their children. These tourists often cite the superior educational and professional opportunities available in the U.S. as their justification to make such a trip. This is insane. This is freaking real, man. This is real. What are we going to do to stop? Oh, imagine that. The U.S. freaking government did the report. So if you don't believe me, that's fine. Don't worry about it. Because I may go through this next time. This looks like a really good idea. We should do this. U.S. Senate Committee on Homeland Security and Governmental Affairs. This is an issue. Birth tourism refers to expecting mothers traveling to the U.S. We already read that. These tourists often sign. We read that too. It means obtaining U.S. citizenship for their children is a hedged bet, a rainy day fund for a better life. Holy cow. So why in the hell are we giving it to tourists? The benefit of U.S. citizenship requires little explanation and should be cherished by all who are presented with such a unique privilege. Absolutely. Birth tourists surely understand the benefits but fail to comprehend the privilege of U.S. citizenship. Birth tourism is problematic because it short circuits and demeans the U.S. naturalization process. Citizenship is not a backup plan. Thank you. And that's the U.S. Senate writing it. This is a problem that we really deal with. This is no joke. So I know many of you are saying there's no such thing as birth tourism. Yeah, there is. Right here. So if the Senate's writing a paper on it, chances are there's an issue. We just aren't addressing it. All right, let me pull up my file here again. Bear with me. Yeah, there we go. Okay. Yep. Yeah, good. We're back. I said that. Here we go. So we've talked about birth tourism. We now know that it's real. We can all agree that it's real. I would hope we can all agree with it. I doubt they would write a paper of that length on something that's fiat, or not fiat, but faux in nature. Let's see. Yeah, if we remove automatic citizenship for children of illegals, it could prevent such. It most likely would. While Wong Kim Ark affirmed birthright citizenship under the 14th Amendment, its application in modern immigration scenarios involving illegal entry remains a matter of interpretation and potential legislative reform. I think it needs it. And again, I don't know if the court can do anything other than stop it. Clearly, an executive order, I don't think it's probably legal. I haven't been through again, they don't teach this in law school. You cover the case and that's it. That's it. You're done. It's just everybody's legal as soon as they come in the door and have a kid. They're legal. That's it. Done. You don't even need an IRAC for that. It's just issue, rule, conclusion. You're done. Only this issue with the executive order has it been brought up that, hey, these Mr. Ark's parents were legal residents when he was born. And I think the court took that as an automatic gimme. And we haven't had a court decide that issue. Does it matter? That's a big deal. So I think in the end, what will happen is it'll get enjoined. It'll stay enjoined. It'll go to the U.S. Supreme Court. What I don't get, it would be quicker, is if they immediately invoked. There's a few things the Supreme Court can do what's called an original jurisdiction, meaning they can act as a trial court. technically, a state can immediately file in the U.S. Supreme Court against another state, the U.S. government. They can duke it out as a trial court for the Supreme Court. They really can't say no. They have to take it. They have said no in the past. They're not supposed to. They're just not. That's original jurisdiction, which a trial court can be there. Maybe they could work out a deal to where the state and one of the states sue the federal government, such as California will probably be the one to do it, sues the federal government and goes direct. They could go directly to the Supreme Court, cutting out years out of the process. But they don't want to do that. They want more to come in longer. Let's keep it longer. Is if they're worried about it getting overturned, why would you take a shortcut? That's a problem. Then again, I think the U.S. government could easily do what's called removal. I can't remember if it's 1331 or 1336. The government can do what's called removal. They could remove it to the Supreme Court in an original jurisdiction and say, hey, we don't need to get caught up in a district court. This is a waste of time. The Supreme Court has original jurisdiction. We're invoking it. Take the damn case. They could do that. That would shorten the lifespan that this case would take to get there, going through the Ninth Circus. I mean, just waiting on a petition of certiorari to the Supreme Court. It'd be a nightmare. It's a nightmare. I don't think anybody's smart enough to do it. I just don't think they care. It's just, I don't. Many developed nations, including most of Europe, do not follow jus soli citizenship and instead confer citizenship based on the right of blood or parental citizenship. We should be able to modernize the approach and be the same. Prevention of abuse. Let's see. Yeah. Prevention of abuse. Anchor babies. Critics argue that automatic citizenship creates an avenue for birth tourism. We talked about that. I apologize. My page went backward. While I can't get this guy's name right. While Wong Kim Ark affirmed birthright citizenship under the 14th Amendment, its application to modern immigration scenarios involving illegal entry remains a matter of interpretation and potential reform. So hopefully this will spur something to be done with it. Either way. Okay? Either way. So at least it'll be settled. I wanted to touch real briefly on the dissent, because I think that's where my guess that's where the Trump administration is going to go. The U.S. government is going to go with this argument. I think. Could be wrong. I think that's where they're going to go. Allegiance and jurisdiction. Justice Fuller argued that the phrase "subject to the jurisdiction thereof" in the 14th Amendment should not simply mean being physically present in the U.S. at birth. Now, he was one of the, I can't remember who the other one was. I think it was Chief Justice that also dissented, but it's irrelevant. Instead, it should require deep, I can't even talk tonight. I'm tired. Apologize. Instead, it should require a deeper legal allegiance to the U.S. It contended that Wong Kim Ark's parents, as subjects of the Emperor of China, owed their primary allegiance to China and not the U.S., and therefore their child should not be considered subject to the U.S. jurisdiction in the full constitutional sense. That's my guess. That's probably the best argument. Is that, hey, these people are coming illegally, and they cannot give allegiance to the U.S. government because they're here illegally. So therefore, they're not subject to the jurisdiction thereof in the full sense of the constitutional term. Everybody gets caught up with the criminal aspect. Oh, well, they're here. They can be taken to jail. They're here. They're subject to the jurisdiction. No, that's not what it means. That's just criminal. Obviously, everybody who comes in is subject to jurisdiction from their body, their corpus, their person. There's a bigger aspect, though. It's always, even in common law, that, for instance, to get citizenship from the king, you had to assent to his kingship, to be a citizen. Without it, you couldn't. You were just another, visitor. You couldn't stay. The jurisdictional issue is probably the best argument and probably where they'll go with it. I could be wrong. We'll know soon. because I think they've only got like 14. I can't remember if it's 14 days or I haven't looked at the federal rules in a while, but the court's given them a time to respond by, and they'll have to file their first response. Um, they being the U.S. government. Um, Instead, it should require a deeper legal allegiance to the U.S. He contended that Wong Kim Ark's parents, hey, I said it right for once, cool, as subjects of the Emperor of China, owed their primary allegiance to China, not the United States, and therefore their child should not be considered subject to U.S. jurisdiction in a constitutional sense. The dissent in U.S. v. Wong Kim Ark, authored by Justice Fuller, Justice Harlan, that was who it was, Justice Harlan, um, expressed a strong disagreement with the majority's interpretation of the 14th Amendment citizenship clause. The dissent argued that the children born to parents who owe allegiance to a foreign power, such as non-citizens, should not automatically be granted U.S. citizenship under the 14th Amendment. I think they're correct. I think they're correct. I don't know how it's going to play out today, but I think too many people get caught up in this political adversity between them. If party A says one thing, well, party B must therefore say the other. I don't see why that has to be a problem unless you're trying to subvert the system enough to where you have control. That's the only reason I could see it being argued that way. What difference does it make? If you're going to give it to children of an illegal, why can't, like I said, a visitor, their child, because they're not supposed to? Do they? Probably. No one's going to go poking and asking, well, were you here on a visa or tourist visa? Or what were you doing? They're just not. They're going to say, well, you're born here. Okay. We've taken it to a whole other level. It's a problem that's not going to get rectified until the court deals with it. Here's a quote from their dissent. The allegiance to which they owed to the Emperor of China necessarily qualified their obedience to the laws of the U.S., and the citizenship of their children born in this country should similarly be qualified. Rejection of birthright citizenship for aliens. The dissent criticized the majority for heavily relying on English common law and argued that the U.S. Constitution not automatically grants citizenship to children of foreign nationals, especially if their parents do not have lawful allegiance to the. Remember, lawful. Lawful. That's a key word. They were lawfully domiciled, and they should have a lawful allegiance to the U.S. These guys left. His parents left. So they clearly didn't have an intent on staying. Maybe they did, and they left because of the discrimination they faced. It's possible. You would think he would have left too. A little odd. Justice Fuller emphasized the idea that citizenship should depend on the political and legal status of the parents. That's probably the best way to go with it. I think the court today would be a lot closer than a 6-2. I really do. I think you'd have a 5-4. I really do. Maybe I'm wrong. Who knows? Weirder things have happened at the Supreme Court that have just shocked me. Recently with Justice Barrett. I've not been impressed with her. I just haven't. And even Kavanaugh, I've been shocked with him too. Been more surprised with Gorsuch decisions than I have anything else. The ones on the left, they don't surprise me. I know how they're going to vote. Although I will say I was a little surprised that it was a 9-0 vote to uphold the TikTok ban. I was really surprised with that. I didn't think it would be 9-0, and that's not good if it is. If you're on the receiving end of that, that's not good. Quote from that part of the case. It's unreasonable to conclude that those who framed and adopted the amendment intended to bring under its protection all alien children born into this country. I think that's probably more correct. Impact of parental status. Justice Fuller expressed concern about the implications of granting automatic citizenship to children of foreign nationals, regardless of their parents' status. He viewed this as inconsistent with the sovereignty and self-determination of the United States, arguing that it could allow foreign governments to indirectly influence citizenship. That's what's happening today. Big problem. Big problem. Yeah, the dissent raised the issue of potential consequences if the U.S. will allow citizens to, for children born to parents with no formal allegiance to the country, implying this could lead to a dilution of the intended scope of citizenship. All true. All true. It's a fact. It's just true. To hold that the 14th Amendment covers the children of aliens born with the U.S. is to extend its operation beyond its proper bounds. I think that's probably true too. I don't think any of these justices would have voted the way they did if they had known what was going to happen in just a little over 100 years. It's disaster. So in conclusion, I know I've gone way over what I was going to, and it pisses me off that I've done it. I hate that I go over it every time. Every time. Oh, I'm gonna do 20 minutes. An hour later. I'm not even sure how long I've been going at this point. Too long. Too damn long. So in conclusion, um, the dissent took a restrictive view of birthright citizenship, arguing that the subject to the jurisdiction thereof required more than just mere birth within the U.S. territory. Fuller believed that allegiance and the legal status of the parents were critical factors, and that the majority's decision granted citizenship too broadly, potentially undermining U.S. sovereignty. This perspective contrasted sharply with the majority's reliance on English common law and its broad interpretation of the 14th Amendment. If the Act of 1866 did not contain the words, and not subject to any foreign power, the children, neither of public ministers nor of aliens in territory and hostile occupation, would have been included within the terms on any proper construction, for their birth would not have subjected them to the ties of allegiance, whether local and temporary or general and permanent. There was no necessity as to them for the insertion of the words, although they were embraced by them. But there were others in respect of whom the exception was needed, namely the children of aliens, whose parents owed local and temporary allegiance, merely remaining subject to a foreign power by virtue of a tie of permanent allegiance, which they had not severed by formal abjuration or equivalent conduct, and some of whom were not permitted to do so if they would, such as China. You couldn't, we had a treaty at the time because of the immigration that we would not do it and not allow it because they didn't allow them to give up citizenship. The emperor maintained it even if they didn't want it. And it was to prevent acquisition of citizenship by children of such aliens merely by birth within the geographical limits of the United States that the words were inserted. 2 months after the statute was enacted, June 16, 1866, the 14th Amendment was proposed and declared ratified July 28, 1868. The first clause reads, we've read that. The act was passed and the amendment proposed by the same Congress, and it is not open to reasonable doubt that the words subject to the jurisdiction thereof in the amendment were used as synonymous with the words and not subject to any foreign power of the act. The jurists and statesmen referred to in the majority opinion, notably Senators Trumbull and Reverend Johnson, concurred in the view. Senator Trumbull saying, "What do we mean by subject to the jurisdiction of the United States? Not owing allegiance to anybody else. That is what it means." Senator Johnson went a little farther. Now, all that this amendment provides is that all persons born within the United States and not subject to some foreign power, for that no doubt is the meaning of the committee who have brought the matter before us, shall be considered as citizens of these United States. This was distinctly so ruled in Elk v. Wilkins, and no reason is perceived why the words were used if they apply only to the obedience, which all persons not possessing immunity therefore must pay the laws of the country in which they happen to be. Dr. Wharton says that the words subject to the jurisdiction must be construed. I think Dr. Wharton was a legal scholar at the time and did a lot of these, like Westlaw does now with compendiums on the law where they bound it all together. Must be construed in the sense which international law attributes them, but the children of our citizens born abroad and foreigners born in the United States have the right, on arriving at full age, to elect one allegiance and repudiate the other. My cousin was born in Panama. Of course, he was in the Canal Zone, so he had dual. Congress allowed for it. They do in a lot of countries. But for him to go into the U.S. military, he had to give up Panamanian citizenship and only be a U.S. citizen. So that is still done. The Constitution and statutes do not contemplate double allegiance, meaning we can't have two masters. Period. You can't have them. You got to have one citizenship. People do it all the time now. Congress allows it. Not really a good idea, but they allow it. It's like getting your cake and eat it too. It's not good. I don't think, because then people can't have allegiance. Because what happens if the two countries go to war? It's not like it hasn't happened before. It happens all the time. The Constitution and statutes do not contemplate double allegiance, and how can such election be determined? By Section 1993 revised statute, citizenship of the children of our citizens born abroad may be terminated in that generation by the persistent abandonment of their country, while by Sections 2167 and 68, special provision is made for the naturalization of alien minor residents on attaining majority by dispensing with the previous declaration of intention, allowing 3 years of minority on the 5 years residence required, and also for the naturalization of children of aliens whose parents have died after making declaration of intention. By Section 2172, children of naturalized, dear God, naturalized citizens are to be considered citizens. All right. The point, however, before us is whether permanent allegiance is imposed at birth without regard to circumstances. Permanent until thrown off by another allegiance acquired by formal acts, not local, and determined by a mere change of domicile. Back then they called it domicile. It's domicile with an E. Domicile is more than just residence. Okay, that is, even for purposes now of suing in federal court. It's not just citizen. You got to have domicile somewhere. I do not insist that, although what was said was deemed essential to the argument and a necessary part of it, the point was definitely disposed of in the slaughterhouse cases. Oh my God, that brings back memories. Particularly as Chief Justice Waite and Minor v. Happersett remarked that there were doubts which, for the purpose of the case then at hand, it was not necessary to solve. But that solution is furnished in Elk v. Wilkins, where the subject received great consideration. It is said, by the 13th Amendment, this is the anti-slavery amendment, slavery was prohibited. The main object of the opening sentence of the 14th Amendment was to settle the question upon which there had been a difference of opinion throughout the country and in this court as to citizenship of free Negroes. Scott v. Sanford. That's the Dred Scott decision. And to put it beyond doubt that all persons, white or black, whether formerly slaves or not, born or naturalized in the U.S., and owing no allegiance to any alien power, should be citizens of the U.S. and of the state in which they reside. Period. That's what the purpose of the amendment was for, not to give it to just any damn person who comes into the United States. That's it, right there. To make it the same for black Americans that had been slaves as well as white. That was the whole purpose. They didn't give a crap about foreigners. That wasn't the point of the amendment. We're using it for something in which it doesn't exist for. The takeaway is U.S. v. Ark. The Supreme Court did not explicitly address the issue of whether a child born to illegal aliens could be a U.S. citizen. Sorry, microphone's acting up. The case primarily concerned the citizenship of Mr. Ark, who was born in the U.S. to parents who were lawful permanent residents, but they were not U.S. citizens. That's a big deal. That's what we need. If anybody takes anything from this, that's what you take. They were here lawfully. That's also what I think the U.S. government will argue when it goes to court. Hey, yes, this is the stare decisis of our country as to what is it, whom is a citizen. But this question was never answered. It was an assumption. We need it answered. We need to know that is it just lawful permanent residents are entitled to this, or is it just anybody, damn person that comes across? Because if it is, then we need to pass an amendment. We need to outlaw it. And that may be the outcome. I don't know. That may be the outcome. The court ruled that Wong Kim Ark was a U.S. citizen of the 14th Amendment, which, again, we just read what the amendment was. Supposed to deal with former slaves. And to put it beyond all doubt that all persons, white or black, whether formerly slaves or not, born or naturalized in the U.S., and who owed, this is the key, you come here illegally, you still have allegiance to your home country. You're not here to pledge allegiance. Not happening. Yeah, they'll do it. They'll do it in a heartbeat and not mean it because they just want to stay. Oh, you mean I can stay if I do this? Oh, okay. That's not what we want. Unless you're wanting to change an electorate. That's the only reason to allow it. Owing no allegiance to any alien power should be citizens of the United States and the state in which they reside. That's the point of this to take home. Always remember that. This is what's going to, I guarantee you it gets argued. I could be wrong, but I don't know what else they would stand on. I really don't. Um, Lawful permanent residents, but not U.S. citizens. The court ruled that Wong Kim Ark was a citizen of the 14th Amendment, which grants citizenship to all persons. We've already covered that. Key points. The court analyzed the meaning of subject to the jurisdiction thereof of the 14th Amendment. It concluded this phrase applies virtually to all children born in the U.S., regardless of the parent's nationality. I think that's more or less where they were going with that in the original case. His parents were Chinese. There was the Chinese Immigration Act to prohibit Chinese people from coming. There was that, and then there was discrimination against them. I think that's probably, I think that's where they were going with it more than, worried about, are these legal? Are these people legal or not? I think they assumed them to be, because otherwise they wouldn't have stated that they were lawful permanent residents in the damn opinion. Now, here we go. Yeah. Regardless of their parents' nationality, except for specific exclusions such as children of foreign diplomats or enemy soldiers in hostile occupation. Parent status. Yeah, here we are. Wong Kim Ark's parents were not U.S. citizens, but were lawfully domiciled in the U.S. The court explicitly recognized their allegiance to the U.S. while residing here, which was a critical factor in its reasoning. However, as we've stated before, the court did not address illegal immigration. I don't think it was a problem back then. It just wasn't, it never came to their minds. Never came to it because they were here. They stayed for 2 decades. Obviously, at the time, they were pledging allegiance. Yeah, they went home, but that didn't change what happened at the time. That's all that mattered. Illegal immigration was not addressed at the time. The concept of illegal immigration, we understand it today, did not exist in the same form. Immigration laws were more limited, and the issue of children born undocumented aliens was not directly considered in this case. Implications for later interpretations. While the decision in Wong Kim Ark established a broad interpretation of birthright citizenship, subsequent debates have raised the question of whether the ruling applies to children born to parents who are in the U.S. unlawfully. However, the court's decision does not contain language that specific limits birthright citizenship based on the legality of the parent's presence. That's going to have to be argued. It's got to be determined. Either way, it's got to be determined. This has to end. And if so, even if they say, no, this is the standing, this is the rule, we're not changing it. Okay, fine. Then the Congress can go in and amend the Constitution. The states could amend the Constitution. They don't need Congress to amend it. It's never been a thing. They can pass it and then send it like a playing telephone as a kid. Well, young people don't remember this. Where you tie a string to cups, and you play telephone. They can do it the exact same way. You just pass it along. Once 3/4 of the state pass it, it's ratified. They give it to the clerk of the no, not the clerk, the chief archivist of the National Archives, and it's an amendment. We don't need them, but it helps if Congress does it. See, while the decision in Wong Kim Ark established a broad interpretation of birthright citizenship, subsequent debates on whether the ruling applies to children born to parents who are in the U.S. unlawfully. However, the court's decision does not contain language that specifically limits birthright citizenship based on the legality of the parent's presence. In summary, the court did not decide whether children born to documented or illegal immigrants are citizens, but the broad principles articulated in the decision have often been interpreted to support birthright citizenship regardless of parental status. And finally, in summary, we are done. I'm sorry it took me this long, but this has been a good topic. I think it's fascinating for a legal point of view. In this case, Wong Kim Ark's parents were legal aliens, and thus his birth conferred citizenship upon him. Whether the idea of citizenship was automatically conferred upon a natural born person to illegal aliens was not applied by the court with specificity. Instead, the court chose to simply view this case as his parents were apparently here legally, and therefore, based upon the principle of jus soli, common law principle, his citizenship was conferred. The court made no ruling as to what would occur if his parents had not been legal aliens. That is most likely what the court will have to decide at this point, and should have done so long ago. However, the court did refer to several times. What the hell? Did refer several times. Let me fix that. It's annoying. No, no, quit doing that. Oh, there we go. To the parents having legal domicile in the U.S., and one could infer, which is what I think the government will do, try to get a new ruling, get a more tailored ruling out of the court. One could infer that this also means that contemplating that this holding applies to children of legal immigration. I just think that it never occurred. I just don't think it occurred to them. I just don't. Illegal immigration was not a problem. It just wasn't. Yeah, they had an issue with, too many of a certain culture or race group, whatever you want to call it. Too many Chinese people coming, too many Jews coming, too many Italians, too many Irish. But the idea of that was just legal immigration with too many, where they had to start limiting it. The idea of actual illegal immigration did not exist then like it does now. It just didn't. Is there an argument against it? I've made that, I think, fairly well. I think. This is please leave a comment or something and tell me what you think about it, because I think it's a fascinating subject, even if it's polarizing. I think it's one that has to be figured out. Regardless of the end, it's got to be figured out. We need an answer. This can't go on. So, in the end, what do I think will happen? I think it'll go to the U.S. Supreme Court, and they'll have to figure out what the hell does subject to the jurisdiction thereof mean. Does it mean that just anybody that comes across the border? If that's the case, then it's going to have to be opened up to everyone, including those on a tourist visa. Doesn't matter. Or even diplomats, kids. They're going to have to. You can't just make it for one group. I think jurisdiction is going to have to mean more than just mere presence. It's going to have to mean full allegiance to the United States. That's going to be, I think, what it turns on. The interpretation aligns with the exclusions recognized at the time of the amendment's adoption, such as children of foreign diplomats, members of sovereign Native American tribes, American Indian tribes, before the Indian Citizenship Act, 1924. I was wrong. It was 20. I said 23. And enemy soldiers and hostile occupation. I think it's going to require more than physical presence, maybe less than complete allegiance. Maybe. I don't know. Because the complete allegiance is, well, what does that mean? Is it just citizenship, or is it citizenship, or is it just mere presence or lawful presence in the country? Which one is it? Or is it none of the above? I can't see the court doing that. I just can't. It makes no sense to have just, it doesn't matter. So I'm not going to go. The rest of this was for me working out the Iraq model of what I just read, which what I just did was basically a law school brief. That's when you brief a case in law school. That's kind of what you do, except you go through and you've got a professor doing this Socratic method with you, constantly questioning you and trying to get you to elicit ideas and get you to work through the issue of whatever the to get you to work through whatever the issue is before you in the case. I think in the end, well, I'm going to leave you with this. Policy implications and sovereignty. This is a good topic. Granting automatic citizenship to children of illegal aliens could incentivize, well, we've talked about that, a birthright loophole that undermines the integrity of U.S. immigration law. It's a fundamental aspect. Always remember that it's a fundamental aspect of our national sovereignty and should not be extended automatically to those who circumvent the process. Many other countries, especially in Europe, do not grant unconditional citizenship by birthright. We need to revisit the amendment. We have to know and we have to know what means subject to the jurisdiction of the U.S. means. That's it. That's all I've got. That is, that's an hour brief, and I could have done it probably a lot quicker if I didn't have to explain everything. But I think that covers the Wong Kim Ark case of what was it, 1898? I think it was 1898. And the basis of that is what we're working on with this new Trump EO or executive order on birthright citizenship. That's what they're going to be. This is what is going to be the springboard from which both sides argue. So with that, thanks for joining me. Look forward to doing this again. And please like, subscribe, leave a message. I appreciate it. And we will, let's see. Do I want to say anything else? Nah, that's it. Yeah, we'll be seeing y'all later. All right. Thanks.